We have some time for questions, and so I'm going to start out with a couple, and then we'll. In fact, Ben just pointed out that the official stats, and this is a question for Julia to start with, that 25% of the construction workforce in New York is unionized. So I'm a little confused because you said that the current prevailing wage law requires that it sets a prevailing wage or defines a prevailing wage as the wage that covers at least 30% of the workers in a given trade in a locality. If only 25% of the state's construction workforce is unionized, how do we have a prevailing wage law that has a threshold of 30% coverage? And in addition to that, what regions in the state have 30%?
So we have this because the state and actually everybody just ignores the 30%. It's like irrelevant. I mean, it's there, it's cited all the time. And by the way, I just would like to mention with things like this 30%, we had put quite a bit of effort in our study looking at trying to calculate what we thought were the real union percentages in New York. So what percentage of different trades were really unionized on the jobs. And we did this because when we were doing the study, many union contractors were telling us that they were going to go non-union. And they also swore us to secrecy and said if we ever told anybody that they were going non-union, there'd be terrible consequences. And so we never did on account of these were very tough guys. So we just left that out of our study and said nothing about it, but we were very aware that big union contractors were going non-union and they were doing it by setting up different corporations. This has subsequently come to pass. Now, the 30% just is simply ignored. And when we brought this up...
Meaning that the fact that there's not 30%.
That there's not 30% any place, probably. I mean, other than Manhattan. Okay, there is 30% in Manhattan on high-rise construction. There isn't in the other four boroughs. I don't think anybody would even contest that. So, and in part, by the way, because the unions never cared about the other boroughs. They never cared about, I mean, they didn't. They would tell you that. This wasn't even, this isn't a criticism that I'm making. So, but when we brought this up, even to the big developers and to the Real Estate Board of New York, we were told to leave it alone. Leave alone the 30%. Now, we actually never understood it. But let me just say one other thing. I mean, why we were told to leave it alone, why everybody ignores this, why it doesn't seem to matter, even though it clearly is not the reality in New York. But just one other thing on this. We are now, at least in New York City, once again, we are back in like, I don't know, 2007. We are at full employment in construction. So, and you know, every developer and contractor will tell you that they cannot find union, non-union, they are all employed. And so what happens, at least in New York with these issues is, you know, in bad times, the developers and the contractors want you to leave the issues alone because they don't want you slowing down, they're trying to get back to work, they don't want you slowing them down. In good times, they don't want to deal with any of these issues because actually they are working and they want to get their jobs done and they don't want you slowing them down. So now we're in full employment once again in New York City, and you know, you can just say goodbye to all these issues in reform.
When you put out this report, as you were knowing, the Wall Street Journal had a story that had covered the people saying, well, you don't understand, union workers are better, it's a higher quality workers.
And they save money. And
they save money.
Right. Now that I call theology and not economics, because that's just the assertion of some pleasant ideas that ultimately you cannot prove.
But again, I don't recall there being dissension over the issue of that the contracts don't actually cover 30% of the work. Nobody said, oh no, they do.
No, right? Nobody, when
that
I say it's
being
ignored,
it
is being ignored.
Okay,
nobody wants to talk about it.
Just want to like draw that fact out.
If you Google 30%, you just, like, nobody talks about it. We talked about it, that was it. Yeah.
That's interesting. Now, on the issue of the scaffold law, Mike, Now, you noted the price differential in New Jersey, which was really extreme for the School Construction Authority and pretty big for the Port Authority. Now, I've got to assume, based on some things I've heard, that there are many severely injured construction workers in New Jersey who are unable to support themselves now because they don't have the same level of work. I mean, I'm being only slightly sarcastic in the sense of, like, are there such stark differences between New York and New Jersey and other states in what is available? What is it? We understand trial lawyers like litigation opportunities, but why is it that in other states we don't have a parade of people, frankly, literally in wheelchairs, talking about how they had a gravity-related, yeah.
You know, it's an interesting question because if you look at those figures and how much higher the losses are in New York, you would have to presume that it must be much more dangerous here, right? There must be a very high incidence
or that
of
nobody
injuries.
is getting paid for their injury.
Right, or you'd look at the costs and say, well, the benefit of these costs would be that we must be much, much safer than everyone else. So we're paying all this, you know, we're driving the insurance market for construction and as a result, the construction economy into the ground. But it's worth that cost because we don't have any accidents. And then, as you note, when the other side starts talking about the law, they start talking about accidents. So the logic of it doesn't really work.
Well,
right?
if
it
we
works so
repealed
well,
this law, what would be the recourse of somebody who had a,
so
as they
the
say,
recourse would be
gravity-related
essentially,
accident on the work site?
it would actually be still broader than it is in a number of other states. So if you and I get hurt at work, or if actually if everybody here gets hurt at work, we're going to workers' comp, except for under some very certain circumstances. And we're not talking about repealing law, we're talking about reforming it, so that instead of having this absolute liability standard, that these workers would still have a special right to sue that frankly none of us have, for the most part when we're injured on the job site, but that you'd apply the same liability standard that applies to every other type of personal injury action in New York and notably in the country, which is comparative negligence. It's a really crazy idea, but what would happen is a judge and or a jury would look at the facts of the case and figure out what actually happened and who was responsible for it, and they would apportion liability accordingly. I agree, it's a radical notion, except that that's how every other type of personal injury is handled. So the idea that somebody who is injured as a result of the negligence of an owner or contractor would not be able to recover is
So in other words,
is
you
untrue.
still, if your employer had
Absolutely.
put up a bad
And it would still
scaffold
be a
and,
greater
could
protection
recover.
than, frankly, construction workers have in most other states. Because there are a great number of states that for whom workers' comp is the sole remedy for these types
That's not
of
the case.
injuries. And you know, one thing that's worth noting, when they repealed the law in Illinois, and Illinois is a state that in many ways is very similar to New York, right? You've got one major urban center, and then you've got the rest of the state that is suburban or to a large degree rural. They repealed it outright, so they didn't reform it, they repealed it outright. And 2 years later, the political tides had sort of returned to their normal state in Illinois, and so the trial lawyers came back to Springfield and said, well, we've got to reinstate, there it was called the Structural Work Act, but absolute liability. Labor opposed the repeal, but Labor did not join the effort and has not supported subsequent efforts to return that law because they have seen the benefit of not only a stronger construction economy, but safer work sites. Because you have it, you know, they argue, well, this removes the incentive on contractors and owners to have a safe work site. That's baloney. I mean, you think about it. When there's not an accident on a job site, of all the people involved in this equation, trial lawyers, contractors, owners, and insurance companies, when there's not an accident, whose business model is that bad for out of those four entities? The trial lawyer, because their phone doesn't ring. When there's a safe work site, everybody else benefits. So there's an incentive for safety. And under absolute liability, it really doesn't matter what the contractor or owner do on safety because they never get an opportunity to go to court and make that case. So they're treated the same way in court as the bad contractor you hear about. And unfortunately, they're treated the same way in the insurance market because it doesn't matter what you did.
Well, we have time for a couple of questions. Questions? Yes?
I'm just curious, which of these three laws mostly pertain, or how do they pertain to local government construction, because that's my area. I would assume the scaffolding law is just law across the board, but as far as the PLAs or the prevailing wage, is that just something where if there's state aid of a local construction project, like for school buildings, it pertains, or what is, do you have a short nutshell answer?
Yeah, for the PLA issue, the decision about whether to require a PLA or not is made by the local government. That's a decision that either the local school board can make. For prevailing wage in New York, it depends on whether it's receiving state assistance. So if you might, let's say your school is funded 80% locally, but 20% with state assistance, that 20% would affect the entire project with prevailing wage rates and increase your costs. So what we've seen a lot of in New York State is local communities figuring out, oh, this prevailing wage law stinks. I don't want your state money, take it, because I don't want to increase my cost to 20% or whatever you're going to give me isn't worth it at increasing the entire project.
Yeah, and you're right, I mean, the scaffold law impacts everybody, and it's worth noting that last year, the largest, of the 30 largest recorded settlements and judgments in New York, 16 of them were scaffold law cases, which is pretty staggering if you think about the fact that there are a lot of other types of civil liability actions that take place. The biggest one was against the school district on Long Island. And the town of Amherst in the last few years had a $23 million $23 million scaffold law judgment against them. They had $10 million of insurance coverage. They took a $13 million hit to their general fund. And ultimately were bailed out by a special deal that was worked out with the state insurance fund, who made them whole on that. And that's why you have the Conference of Mayors, the School Boards Association, the Association of Towns, school superintendents, all part of the coalition that are calling for this, because in the best case scenario, they're all paying more for what they need to build, and I think every locality, just like the state, has less money than they need to do what they need to do. And in the worst case scenario, they're getting hit with these lawsuits where, in all likelihood, they have nothing to do with the injury.
We have time for one more.
Can I answer that?
Yeah.
Because it's actually a very interesting question, the locality part on prevailing wage. And the answer is it's a big mess, and it varies tremendously around the country. 32 states have prevailing wage, 18 do not. Of those 18, 9 are relatively recent repeals. Of those 9, then some localities, in some fit of, I don't know, well, I shouldn't use a noun. Some localities then reimposed prevailing wage on themselves, tremendously increasing their local costs. In New York City, prevailing wage is controlled by the controller and not by the mayor. The controller sets the rates. The Bloomberg administration tried to hold the tide on that, and for example, on, of all things, elevator workers who, what do elevator workers have to do with construction? It's just the way it is. The controller said, yes, they're on the prevailing wage. It's going to cost New York another $10 million just for the elevator workers, like sort of out of the blue. And the de Blasio administration has indicated they're going to look through all the categories that aren't covered by prevailing wage. In other words, not construction workers, but all these other categories. And they're probably going to put them in prevailing wage. Meanwhile, I'll finish, EJ, but meanwhile, in all sorts of other localities, for example, small towns on the Cape, Massachusetts has a very aggressive prevailing wage law, and small towns that actually have to fix themselves if they're going to survive are trying to get out of prevailing wage, and that's a big movement, so it's a mess.
Well, thank you. I think that's pretty much, we want to get everybody out of here on time, so I want to thank our speakers and our panelists very much, and thank the audience. Thank you.